ICAEW, that is the Institute of Chartered Accountants in England and Wales. As you probably know, the pass rate in the ICAEW exams is about 40% as compared to the Indian CA rates of 1.2% in a good year. Now you know the reason why I went to UK to do my CA. Anyway, that's incidental. So let me thank the organizers at the outset for inviting me. In fact, Mr. Raju spoiled my remarks by saying that I was with his father. Actually, yes, I had the pleasure of being a member of the SIRC with Mr. Gopal Rao, that is Raju's father, and that was a memorable year because we had lots of fun. And anyway, that was way back. So today I'm associated with Mr. Raju and of course with Mr. Dhanpal, with whom I have shared many forums in the last 1 year. One of the most dynamic company secretaries I've had the pleasure of working with. And I look to a continued association with both Mr. Raju and Mr. Dhanpal. Now, as for the program sheet and minute by minute itinerary, I have been given time of 10 minutes for the initial opening remarks of the chairman of the technical session, that's me, and at the end of it, after Mr. Arun Pandyan's presentation, another 5 minutes for summing up. What I would rather like to do is that, pass on these 10 minutes to Mr. Pandyan, because I think he is the speaker and it's better that you hear from him than from me. And primarily because anything I say now is going to preempt, and I don't want to land myself in an embarrassing situation where half an hour later Mr. Arvind Pandyan has to say, sorry Mr. Kumar, what you said about half an hour ago is not correct, and this is the correct position. So sometimes they say silence is golden, and one wise man had said, it's better to keep your mouth shut and be thought an idiot than to open your mouth and prove it. So, so I would like to pass on my 10 minutes to Mr. Pandyan, and sir, please take as much time as you want, because it's actually going to go back to about a couple of months earlier, when Mr. Raju called and said, Mr. Kumar, we want you to be the chairman of this particular session. I said, speaker, yes, of course, Mr. Pandyan, I have great regard for. And I said, what are the topics? The topics are class action suits, special courts, NCLT, and schemes of arrangement. Then I said, Mr. Raju, none of these topics I'm an expert in, because as you know, I'm a practicing chartered accountant. Unlike tax laws, where chartered accountants have a lot of role, and then we do a lot of tax work as accountants. But when it comes to Companies Act, we are not really, into that, all that much into the subject. Especially when you look at these three out of these 4 topics: class action suits, special courts, NCLT, they're all litigation support services, which is of course a lawyer's domain. So I said, I don't have a right to be a chairman of this because I'm not aware of the topic. Then Mr. Raju said, Mr. Kumar, you got 2 choices, because this was about 2 months ago when he called me. Either you acquire expertise in the next 2 months, or you come as you are. It doesn't make any difference, because Mr. Pandyan is going to be the presenter, and even if you're dumb, you just have to sit there. Mr. Pandyan will take over and he will run the program, so it doesn't make any difference whatsoever. So under the second premise, I'm here today. I'm still dumb. Anyway, so Mr. Pandyan, I would really like you to take as much time of mine as possible, so to relieve me of my responsibilities, for which I would be grateful. So ladies and gentlemen, Mr. Pandyan, thank you.
Chairperson of this session, Mr. Kumar, Mr. Raju, the organizers, Mr. Dhanpal and his team, all the professionals here, ladies and gentlemen. I think first thing in the morning, being here gives me a great pleasure, for a simple reason. I don't need to put extra effort if it's after tea or after lunch. So I'll have the best of the attention so far as some of the topics are concerned. I'm sorry I've gone through this, so I know it. Please don't mistake me. And the topic's not a bit dry. I'm meaning it from that angle, so I'm going to juggle between them. But before I start, as Mr. Kumar had said, there's one saying also which goes, the fools like to be visible and the wise have the last laugh watching them. So I was immediately, reminded of it when you said that you would like to listen to me more rather than having to contradict me or me contradict you 40 or 30 minutes down. And I would only put it this way, sir, personally, not only to you, but also to your profession as such. It's one of the most humble and most knowledgeable professions which I respect, rather than my own professionals to be with what you read about us in the newspapers or wherever. But still, forgetting all that, at least having called me here to address gives me the respect what you have for the profession where we come from, that is from the angle of practical aspects. That brings us to the second point. If he said that he got a CA degree with, where 40% was a pass, well, our pass percentage, leave apart, our pass mark is lesser even than that. So we get a law degree with that. So please imagine where we come from. But ultimately, the only thing what we gain is experience or the practical aspects which come about in the last 15 or 20 years, which also puts us on par with you, sir, to sit either on that podium or maybe address you all. So I just wanted to also add that we are surely no better than y'all or no worse than y'all. You can put it from both angles too. Before I start the topic, I would also like to record the effort taken by the organization, which usually used to be done only by any of the institutes or their own chapters and the chambers. These are the three places which I remember speaking in the last 15 or 18 years, I should say, and with a little bit of jealousy too, I should say. Even our own profession, we don't have any such forum at all to speak, so we find ourselves only before the three institutes and the chambers, but with no effort spared, and without any exaggeration I should say, you have brought in 10 times the amount of participants than done by those three institutes or the chambers as such. So I think that's a huge effort to bring about an awareness to ensure that these kind of minds come together to discuss, deliberate, and hear what we have to say. So at this moment, I only take it that please do not think that we are here to present something which we already know. We are also learning it with y'all. We are also trying to interpret it or criticize it or even critically analyze it. So whatever I place could be only about 30 or 40% of the actual practical aspects of these, but how they will be when it gets interpreted, we'll have to wait either for the NCLT or the other institution which comes to administer these. So the four topics which are there, I would not like to start in the same order. I'm going to juggle it again. As Mr. Kumar had said, I would like to use the maximum area towards the arrangements or the provisions relating to corporate restructuring, because that's where I think people have interest in to know what they are now and how different they're going to be from the past. And then maybe touch upon what is NCLT. Then go into the academic area of the class action suits, a little bit which people don't want to go, that is the special courts for the criminal offences. So I will touch those two with a very, very brief overview at the end. But this is one area where I feel more impetus should be. I have circulated a paper, maybe it's possible you might have it, but I'll just run through from the place where these provisions start. The schemes of arrangement, again, arrangement doesn't find itself defined in the new act. The old act had a provision of 390. Yeah. There are 10 sections here, 230 to 240. What was in about 7 sections, 390 to 396 capital A, have sought to be compressed. That's what I call into 10 sections. So though the act comes down, the number of sections for these go up. We have to take it, they have tried to cover a few more areas which they felt the 50 years of law either had to be nullified or either had to be expanded or recognized. The provisions of through 230 to 240 also run in the same sequence as how provision of 391 to 394 also are in relation to scheme of arrangements, compromises, or amalgamation or reconstruction is what we call. We now find the word merger also into the provisions. So accounting wise, how you're going to interpret it, it has to wait for any decisions, because the merger concept understood under the accounting standards is completely different from the merger concept understood under the Companies Act. We were always looking at it as an amalgamation, though amalgamation defined in section 2(1)(b) of the Income Tax Act was there, which was relevant also for the accounting standards 14. That did not worry us insofar as Companies Act goes. The same way, demerger also doesn't find itself defined under the Act, but it does find itself under the rules. So when I come to that slide, I will be telling you, but practically speaking, how far a section could be overridden by a rule, we will go into interpretation of statutes to say that a demerger, they have stated that to qualify for it and cut and paste exactly 219AA from the Income Tax Act and pasted it in the rules. But the word reconstruction alone finds its place. There are many extra provisions for demerger which affects here. But for all these purposes, who can apply for all these remains the same. There are 4 parties who apply for any of these provisions: a member, a creditor, or the liquidator, or the company itself. So who can apply has remained the same. But when they apply, who hears these? As of now, we have the High Court, which hears either the convening of meeting or the dispensing with of meetings of the classes. The section also refers to the tribunal to be hearing this. Tribunal as such means a bench of the tribunal is what we understand. But the rules, particularly rule, if you say 15.1.2, the draft rules, it says otherwise that the registrar shall be hearing. A registrar is supposed to be only an administrative head or a procedural head. So a meeting could have certain disputed facts. How that is going to be deemed as a tribunal hearing is what we need to wait and see. But that rule is still in draft, so if a comment goes on that, how they're going to correct it or not, but still it would be wrong to say that the registrar will be hearing these applications. It's going to be a little bit tough for a legal proposition to be raised before a registrar, because he's not a qualified tribunal member. A tribunal member, we have the various qualifications given who should hear. So if he is supposed to be the qualified persons to or person to hear any of these, I would say the disputable question of facts, is a registrar qualified to be that person, a retired judge or a chartered accountant or a company secretary or whatever, but he's going to be from maybe some department. That becomes a vague proposition in the rules. Then the disclosures to be made under section 2302A effectively doesn't change. 393, if you see, and particularly 391, 1 deals with the meeting, 391.2 deals with the disclosures, 391.2 is pari materia to 230 clause 2, and it effectively says the material facts, the latest financial position, latest auditor's report, pendency of any investigation or proceedings initiated against the company. Now, the first 3 are virtually the same. The 4th came about to be interpreted by the various high courts and said that you can only disclose matters related to Companies Act. Finally, it got a bit vague, and the court said you can disclose anything, any litigation. So there's 2 views on this. Just 1 week back, on January 14, the department again came out with a clarification for the present mergers. I'm not talking about the new act. For the present 394 capital A, which talks about the regional director's objections to these mergers. There, they've clarified that proceedings includes any proceedings, and the regional director has to write to the income tax department. Now they're virtually, because they find that this is getting delayed now, the NCLT and also the notification of these provisions, so they've tried to bring it through a back door. A notification has been issued where they send the notice to the income tax department that kindly object to the scheme or whatever, and wait for 15 days, and if 15 days the income tax department doesn't respond, then it's taken as a deemed consent.